Hello everyone, welcome back to our channel Law Point. This is Renu Thomas, your host. In our previous episodes, we have seen what are the different types of punishment under the Bharatiyanyayasanhita. Today, we are going to see what are the different directions, limitations and conditions, and also to the extent to which these punishments would be given by the courts. We have with us Mrs. Praseena Elizabeth Joseph, advocate on record from the Supreme Court of India, to explain the same. So let's watch this episode.
In our Indian criminal legal system, a person accused is convicted and sentenced to a punishment only if the prosecution is able to prove the case beyond the shadow of reasonable doubt. That means the prosecution evidence against the accused need to be foolproof. Otherwise, if there is any shadow of doubt on this aspect of crime being committed by the accused, then the benefit of doubt is available to the accused and he cannot be punished. Now let's see what are the limitations or the factors which the court consider while giving punishment to an accused. If a person is sentenced to an imprisonment for a period of 8 years, then it is for the court to direct whether the person has to undergo this 8 years fully by rigorous imprisonment or by simple imprisonment, or part of the sentence, for example 4 years rigorous imprisonment and the remaining 4 years simple imprisonment. If an accused is sentenced to undergo rigorous imprisonment for a heinous crime, then the court can also direct whether the accused can undergo this rigorous imprisonment or part of their sentence in solitary confinement. Solitary confinement means the convict is kept in a room or a cell with no contact with other prisoners in jail. However, there are limits of keeping that person in solitary confinement. It can be for a limited period of time. If a convict is sentenced for an imprisonment for a maximum period of 6 months, then the solitary confinement can be only for a period of 1 month. If the convict is sentenced to an imprisonment between 6 months to 1 year period, then the solitary confinement can be only for a period of 2 months. If a convict is sentenced to an imprisonment for a period more than 1 year, then the solitary confinement can be imposed up to 3 months. There are further restrictions as to how solitary confinement can be carried out. Solitary confinement cannot be imposed for a period longer than 14 days at a time. For example, if a convict is sentenced for solitary confinement for a period of 1 month, then there shall be a gap after 14 days time. He cannot be all throughout for 30 days be under solitary confinement. Solitary confinement is a form of disciplining, however, that is rarely used because of its severe effect on the mental and physical health of the prisoner. Now let's see, there are enhanced punishments for repeat offences. For example, an accused is convicted for an offence of theft, robbery, dacoity, trespass, mischief, counterfeit of coin, currency, government stamp, etc. And he is sentenced for an imprisonment of 3 years or more. And if the accused is subsequently convicted of any of these offences, then he will get a harsher punishment for the subsequent crime, that is life imprisonment or 10 years imprisonment. Another important aspect while giving punishment by the courts are, for example, an accused strikes a victim 50 times with a stick and causes hurt or grievous injury to the victim. In this case, the accused is not punished for every single blow, potentially leading to 50 years of imprisonment for giving 1 year punishment for every single blow. However, this person is punished in a way that gives one punishment for the entire act of beating. However, during this beating, another person intervenes and he also gets hurt because of this blow, then in that case it is considered as a different offense wherein the accused is punished for causing hurt to the main victim and he is also punished for causing hurt to the third party who intervened while he was beating the victim. Another important aspect while giving punishment by the court is, for example, if a group committed murder of a person by causing grievous injury to that person, in this case, if the investigation is not proper or the evidence is not sufficient to prove on whose blow the death has been caused, then in this case, the accused get benefit of doubt. However, they will be punished for causing grievous injury to that person because there is a common intention and evidence available to show that all of them caused grievous injury to that person. However, they may not be convicted or punished for murder.
I hope you liked this session. Thank you for watching. Meet you in the next episode.